India Legal presents Court This Week.
Hello and welcome to Courts This Week. I'm Hishe. In this special edition of Courts This Week, we bring you top stories of legal proceedings from courts. From lower to subordinate courts to High Court and Supreme Court, we bring you a selection of major legal proceedings which made headlines this week. In this next half an hour, we'll bring you and inform you and update you of all the important proceedings from the week. So let's start Courts This Week.
India Legal presents Court This Week.
The Supreme Court has quashed the notification on the conduct of Bangalore-based National Law School of Indian University's separate entrance exam called the National Law Aptitude Exam 2020. The top court ordered that this year the NLSIU will have to conduct its admissions to its courses through the Common Law Admission Test. According to the court, CLAT 2020 will have to be held on its scheduled date of September 28 and concluded that the conduct of CLAT 2020 should not be hindered by NLSIU in any manner. The Supreme Court has quashed the conduct of National Law School of India University Bangalore's separate entrance exam, the National Law Aptitude Exam 2020. The court ordered that NLSIU would have to conduct admissions to its courses this year through the Common Law Admission Test. The bench of Justices Ashok Bhushan, R. Subhas Reddy and M.R. Shah had reserved judgment in the matter on September 17th after giving the case an extensive hearing. Earlier, the court had allowed NLSIU to conduct the contentious NLAT. However, the apex court had held that the result would be declared subject to the decision of the court. The court had directed that CLAT 2020 be held on its scheduled date of September 28 in accordance with all the safety guidelines prescribed by the Union Ministry of Health and Family Welfare. The court further directed the result of CLAT 2020 are to be declared as early as possible to ensure that universities can start admission as soon as possible. Further, the court has directed that NLSIU be reinstated to the Secretariat of the NLU Consortium and that the Vice-Chancellor, Professor Sudhir Krishnaswamy, be given back his post of Secretary-Treasurer of the Consortium. NLSIU's move to conduct a separate entrance exam this year, owing to the delayed conduct of CLAT 2020, was challenged by former NLSIU Vice-Chancellor Professor Venkata Rao, along with an aspirant parent. The court was urged to quash the September 3rd notification announcing the conduct of NLAT for NLSIU admission this year. Another prayer was made for quashing of NLSIU's notification regarding the technical requirements to write NLAT and for a direction to the university to accept students this year on the basis of CLAT scores. One of the central points of contention in the matter was NLSIU's unilateral decision to hold a separate exam whilst being part of the consortium, a society which had come to be formed primarily for the purpose of holding a common law entrance exam for admissions to NLUs. Bureau Report. The Supreme Court ordered a status quo on the transfer or pledging of Tata Sons shares by Sapurji Palonuji Mystery Group companies, ruling in favor of the Tata Group. Order restricts the SP Mystery Group from transferring or pledging Tata shares for the time being. The top court said it would take up the matter for hearing or final argument on 20th of October, directing the parties to maintain status quo till then. The Supreme Court has restrained Cyrus Ministry Shapurji Palonji Group from pledging any of its shares in Tata Sons for raising funds. The company has also been directed to maintain status quo and not to take any action as regards to the share already pledged. The bench of Chief Justice of India S.A. Bobde and Justices A.S. Bopana and V. Ramasubramanian passed an order to this effect while hearing an application filed by Tata Sons challenging SP Group's move to pledge its shares in Tata Sons for raising monies. This application was filed by the Tata Group after the SP Group proceeded to enter into an agreement with a Canada-based company to raise monies to turn off 3,750 crore rupees by pledging its Tata Sons share. Tata opposed this move on the ground that the Articles of Association bars the SP Group from transferring the shares without first giving Tata the right of first refusal. Appearing for Tata, senior counsel Harish Salve told the court that if SP Group wishes to sell the shares, Tata is willing to buy them. However, they have chosen to hold on to shares and instead pledged them for raising funds. It was further argued by Salve and senior counsel Abhishek Manu Singhvi that the shares could not have been pledged. This point, however, was contested by senior counsel Aryama Sundaram. On behalf of Cyrus Investment, he said that the Articles of Association bars the transfer of shares and not their pledging. CJI Bobde noted that it has been held on various occasions that pledging is in fact a limited transfer itself. The bench also noted that the matter needs to be heard at length for final disposal and proposed to place the case for final hearing after 4 weeks. Senior advocate Janak Dwarkadas, appearing for Cyrus Misty along with Sundaram, argued that the restructuring of the company was scheduled shortly and that the company had to disburse salaries of a number of its employees and migrant workers. However, both sides ultimately agreed for the matter to be heard after 4 weeks while requesting for status quo. The Supreme Court proceeded to direct for status quo to be maintained on the aspect of transfer and pledging of shares by SP Group. It added that the SP Group ought not proceed further or take action on the shares already pledged thus far. The case will be heard next on October 28th. This application was filed by Tata Group at a time when the appeals by its chairman Emeritus Ratan Tata and various other Tata companies against the NCLAT's December 2019 judgment remain pending before the Supreme Court. The cross-appeal filed by Misty against the NCLAT's ruling of December 2019 is also yet to be heard. Bureau Report. The Delhi High Court set aside the ex parte interim injunction order restraining the publication of a book on Asaram Bapu's title, Gunning for the Godman, the true story behind Asaram Bapu's conviction. The order was pronounced by the single-judge bench of Justice Najmi Waziri in HarperCollins' appeal against the injunction order passed by a district court in a suit preferred by co-convict in the Asaram Bapu's rape case, Sanchita. The court directed that the already printed copies of the book to be sold along with a flyer clarifying that the book is based on the judgment of the trial court, which is under appeal. For online sale, the disclaimer should be given electronically, the court added. Seeking a vacation for the stay order, HarperCollins had contended that pre-publication censorship ought to be done very cautiously and that there was no occasion for the same in the present case. Sanchita, on the other hand, argued that her right to reputation and fair trial ought to be balanced with the right under Article 19(1)(a) of the Constitution. Stating that the appeal against the conviction was still pending, it was claimed that there was a continuation of trial and irreparable injury would be caused if the publication of the book was allowed. The book, Gunning for the Godman, the true story behind Asaram Bapu's conviction, is authored by Ajay Lamba, Additional Commissioner of Police, Jaipur, and Sanjeev Mathur, and was scheduled to be released on September 5th this year. The Court of Additional District Judge has stayed the publication of the book on the ground that the appeal against the conviction in the rape case was sub judice before the Rajasthan High Court. Jodhpur bench of the Rajasthan High Court has wrapped on the CBI court for issuing arrest warrant against former Union Minister Arun Shourie and 4 others in connection with the disinvestment of Lakshmi Vilas Palace Hotel of Udaipur. A single bench of Justice Dinesh Mehta observed, while issuing an arrest warrant, court below has not recorded any finding as to why petitioner's custodial interrogation is required, particularly when all the relevant documents are on the record of the court below. The transaction dates back in the 2001. When she was not at the helm of the affairs of the company. It may be noted that apprehending the possibility of arrest following the order of the special CBI court, Jyotsna Suri, the managing director of the Bharat Hotels Limited, filed a plea in the High Court by the bench of Justice Dinesh Mehta. It was submitted by the counsel for the petitioner in the High Court that without even putting her on notice or issuance of summons by the special court, the issuance of an arrest warrant directly was bad in the eyes of the law. Senior counsel P.P. Chaudhary and Harish Salve were representing Jyotsna Suri before the court. It was argued before the court that the CBI itself has submitted before the court that since there was no evidence of illegality, the case against the accused should be closed. In these circumstances, it was contended the special court was not justified to reject the closure report filed by the CBI without any sound basis. Apart from this, the bench also ordered that the possession of the property be given back to the private company that ran it. The court also ordered that the petitioner shall not be arrested. And now it's time for a short break. We'll be right back.
India Legal presents Court This Week.
On the question of who is liable to pay compensation to the employees with expired driving license in an accident, the Apex Court in its judgment has said that an insurance company cannot be made liable in the event there was an expired license held by the driver who was driving his employer's insurance vehicle. The Supreme Court has held that liability of compensation cannot be fastened on an insurance company when the driver of a vehicle involved in an accident does not have a valid driving license. The Supreme Court bench of Justices Sanjay Krishna Kaul, Anuruddha Bose and Krishna Murari was considering the question of whether an insured employer would be absolved of liability in a case where his employee drives a vehicle owned by the employer and meets with an accident while holding an expired driving license. In this case, the respondent was gainfully employed by the appellant and had suffered 20% of permanent disability after meeting with an accident while driving a truck owned by his employer. The Supreme Court notes that it has been unable to trace out any precedent laid down by the Supreme Court on this issue. However, the Apex Court had the benefit of a number of High Court judgments on this aspect of law. It was argued before the court that the employer as an insured had taken due care at the time of employing the respondent to ensure that he held a valid driving license. However, the renewal of the license ought to have been the responsibility of the respondent. It was pleaded by the appellant. The court, however, observed, "We are of the view that once the basic care of verifying the driving license has to be taken by the employer, though a detailed inquiry may not be necessary, the owner of the vehicle would know the validity of the driving license as it is set out in the license itself. It cannot be said that thereafter he can wash his hands of the responsibility of not checking up whether the driver had renewed the license." Having said so, the court also underlined that the claimant in the case, that is the workman who suffered disability, was negligent to the extent of not renewing the license. However, the case before the court was that of the Workmen's Compensation Act and not that of the Motor Vehicles Act, the court added. The court referred to a Delhi High Court judgment in the case Tata AIG General Insurance Corporate Limited versus Akanksha and others, where the ounce to prove that there was no breach of insurance policy was shifted to the owner insured after the insurance company showed that valid license did not exist on the day of the accident. Supreme Court said that it was the responsibility of the employer to ensure that the valid license was renewed when it expired, especially since the workman was engaged in driving a commercial vehicle. Since the instant case is a matter under the Workmen's Compensation Act and not the MV Act, the consequences do not flow to the respondent who suffered the accident and who was also negligent to the extent of not renewing his license. Since there is no third-party claim and no other person suffered in the incident, the respondent was not held liable by the court, which proceeded to dismiss the appeal and effectively upholding the liability fastened onto the employer in the case, who was the insured party and owner of the vehicle. Bureau Report.
The Supreme Court has dismissed as withdrawn a plea filed on behalf of Sudha Bhardwaj, accused in the Bhima Koregaon case, seeking interim bail amid the COVID-19 pandemic. The Supreme Court observed that Sudha Bhardwaj had good grounds to seek bail on merits of her case, while it declined to entertain her bail plea filed on medical grounds. A bench of Justices UU Lalit and Ajay Rastogi heard a plea against the Bombay High Court order, which had dismissed Bhardwaj's earlier attempt to get interim bail on medical grounds amid the pandemic. Appearing for Bhardwaj, advocate Vrinda Grover sought interim bail on the ground that her client was suffering from diabetes and other comorbidities. Grover said that while spending the last 2 years in jail, Bhardwaj had developed arthritis and a heart condition. When Justice Lalit noted that the High Court order stated that Bhardwaj's medication was in order, Grover said, "I only seek your indulgence to get checked. This test cannot happen in the jail hospital." Justice Rastogi then asked Advocate Vrinda Grover, "Are you saying this report is false? You have a good case on merit. Why don't you file a regular bail application?" While the court noting that Bhardwaj's condition needed a deeper look and that a regular bail plea could be filed, the plea was dismissed as withdrawn. Sudha Bhardwaj has been lodged in Mumbai's Byculla Women's Jail since 2018. She had earlier filed an appeal before the High Court after the special NIA court rejected her bail plea. While holding that no case was made out of for the interim bail, the High Court noted that the National Investigation Agency and the Maharashtra government and the prison authorities were taking all precautions to prevent the spread of coronavirus and that she was being given the necessary medical care. The High Court has also directed Maharashtra government to submit Bhardwaj's latest health report and an affidavit within a week clarifying how it proposed to implement safety guidelines and the court's PUCL judgments in the Byculla prison to protect inmates. A Delhi court has remanded former JNU student Umar Khalid to judicial custody till October 22nd in connection with the Delhi riot case. Khalid was arrested by the Delhi police on September 13, pursuant to a FIR filed under the Unlawful Activities Prevention Act in connection with the riot that broke out earlier this year. Khalid was virtually produced before Judge Amitav Rawat, Additional Session Court, Karkarduma, after his 10-day police custody ended today. Delhi police sought a direction from the court to send Khalid to judicial custody. After the order, Khalid requested the court to allow him to meet his parents and also carry his spectacles and a book to jail. The court thereafter asked him to move an appropriate application for direction to carry his spectacle, etc. to jail. It is the prosecution's case that the Delhi riots were part of premeditated, deep-rooted conspiracy which was hatched by Khalid and his associate from various organizations. In furtherance of the conspiracy, police had claimed Khalid gave provocative speeches asking citizens to come out on the street to protest and thus spread the propaganda about the minorities in India being persecuted. While observing that prostitution has not been made an offence under Immoral Traffic Prevention Act 1956 and that an adult woman has the right to choose her vocation and cannot be detained without her consent, the Bombay High Court set free 3 sex workers from the Corrective Institute. The court also said that the act does not empower the magistrate to hold the custody of the victims beyond the period of 3 weeks without there being any final order to that effect after following due process of law. The court then observed that Section 17(4) of the said Act provides that after completion of the inquiry, if the magistrate is satisfied, he may, subject to the provision of subsection 5, make an order that the victim be detained for such period, being not less than 1 year and not more than 3 years, as may be specified in the order, in a protective home for which the magistrate shall give reasons in writing. It is pertinent to note that the court observed that the provision of Section 17(4) of the Act are subjected to the provision of subsection 5, which provides that the inquiry shall be conducted by the panel at least 5 persons to be appointed in the manner as contemplated in the said subsection 5. No such inquiry as contemplated under the statute was conducted in the case. The court also noted that Section 17(4) implies that an order under the said section can only be passed subject to the provision of subsection 5, Section 17 of the said Act. The Allahabad High Court has issued a writ of mandamus for the whole of state of Uttar Pradesh and that no person should be seen outside his or her house without a mask on his or her face, and he or she should check that the mask covers both the nose and the mouth. The division bench of Justice Siddharth Verma and Justice Ajit Kumar was hearing a public interest litigation regarding inhuman condition at quarantine centers and for providing better treatment to the corona positive. The court noted to stop the spreading of the pandemic, humanity has realized that the only method available was that it has to maintain social distancing and wear masks. Further, the court observed that it was convinced with the study shown in the journal New England Journal of Medicine, leading to the conclusion that the 100% population masking is the only strategy by which we can attempt to containing the spread of pandemic COVID-19 totally. Though the court did not doubt the concerns shown by the administration and the bona fides of the public police administration in the city to take steps to convince and at times force people to wear masks so that the pandemic is contained. However, the court noted from the photographs that were brought on record by the learned Additional Advocate General as part of the instruction that huge assemblies of people at various places and still there and the people are not wearing masks as routine. The court further directed that the police in all the districts of the state Uttar Pradesh should in all police stations of all the districts deploy task forces to implement this mandates. Each task force should consist of much more police personnel than presently have been deployed. In this context, the court issued a writ of mandamus for the whole of the state of Uttar Pradesh that no person should be seen outside his or her house without a mask or his face. That's it for Courts Roundup today. Thank you for tuning in. Keep watching APN for more updates from around the nation.
India Legal presents Court This Week.